Hey everyone, welcome once again to Fitz in Law School. I'm Fitz, and today we're going to be talking about civil procedure. Just like last week, we did a quick rundown of torts, and then we focused on like kind of a main subject about torts, negligence, and all that fun stuff. Today we're going to be talking about civil procedure. So, civil procedure is a super interesting class because it talks about the rules, overwhelmingly the rules of civil procedure, and how to do things, how to bring about a complaint. I don't know about you, but I had no idea that there were rules to the civil procedure. I mean, I'm not quite sure what I thought it was. I thought it might have been, I don't know, a number of standardized forms that everyone knew how to use, and it was just the same throughout the entire process. You know, I don't know. But yeah, but there are rules. There are rules on how to do it. You know, it's a whole game. It's a whole thing, and they have a list of rules. Rule 1, rule 2. I mean, it's pretty interesting to it's pretty interesting to see that in play, in action, and to also see how it not only it's been changed over the years, but also how the courts have then interpreted the use of those rules within the civil procedure. So I want to talk about two things. The first thing I want to talk about is and this is something that like we really focused on for a lot of the time, is pleading. And that is like bringing a claim in general. In civil procedure, there's something called Rule 8. Okay, so Rule 8 is essentially, it's what a claim should be. When you go and bring a lawsuit, you have to say, essentially, so this is the language of the rule. The language of the rule is a short, plain statement showing why the claimer is entitled to relief. You know, that's it. That's all it needs to show. It's a rather, depending on what you're trying to prove, a low bar to overcome to even have a federal court consider hearing your case. And so there have been lots of different ways that it's been interpreted over the years, but the two big cases where it's been interpreted are the Twombly case and the Iqbal case. Every single law student in the world will say, oh yeah, that's Twickball. So first, we have the Twombly case. Okay, so Twombly was essentially this guy who was representing a class action who brought about this action against every single, cell phone carrier and yeah, in the country. And he was working on have this class certified, and it was going to be the largest class action in history, and it was going to be, 250 million people who were part of this class action. And it was against, all the major cell phone companies. And what they were claiming is they were claiming that they had a conspiracy, and they were defrauding all their customers, and they were keeping their, all their rates at the exact same place, and they were doing everything at the exact same time, and not allowing any person a choice. And essentially what they were doing is acting as a monopoly. And essentially what they said was that it's not really enough. I mean, the language is a short, plain statement of claim showing pleader is entitled to relief. Okay? And so what they really focused on is showing, the word showing. And so essentially what they said is that a claim needs to show not only the facts alleging the claim, but also that the claim be plausible. And so that was a huge reinterpretation of what that was. And the courts kind of focused on one main thing, saying, are they really acting as an enormous monopoly and they have a ton of and if they have an enormous conspiracy, or is what they're doing just kind of good business? One of the companies decides to do something, and then the others follow suit because they say, oh yeah, it's a great idea. So this was a big kind of reinterpretation of Rule 8. The court system is designed to allow people to go and bring about a claim, and if their claim is meritorious, then they would go and get heard. And this kind of upped the ante a little bit. It upped the amount of things that you had to do before discovery, before all these different things, which would allow you to kind of win your case. And I think the court was also recognizing how much this was going to cost, how much discovery, how hard the case would be, that they just kind of said, it's not really worth it. That being said, if there was a massive discovery, then or a massive conspiracy, it might be pretty hard to hide that. So I don't know. But so that was one kind of reinterpretation or tweaking of Rule 8. And a lot of the stuff comes down from the Supreme Court. In fact, it almost has to. And the other one was the Iqbal case. Essentially what this was a sweeping up of the post 9/11 kind of crazy things that the Bush administration was doing, where they were going and kind of rounding up people who they thought were terrorists or they thought might have been terrorists or something like that. And what this guy was doing was he was saying that he was part of this group of people that was, swept up in and unlawfully detained and all these kinds of things simply because he was Middle Eastern. And John Ashcroft and Robert Mueller, who was the director of was the Defense Department and FBI, respectively. I know Robert Mueller was the FBI. I think John Ashcroft was the Secretary of Defense after Donald Rumsfeld? Might have been. But essentially, what it was they were saying that these policies were based on racial motivations. They were racially motivated, and I was someone who suffered from that, so I should be able to hear that. So this was one of the things where it was dismissed over and over again in the lower courts because of their failure to state a claim that properly adheres with Rule 8. And so what the court said that even if the facts of the case in your claim give rise to an inference, the inference alone is not enough. And so once again, this was kind of another thing that was going off of the Twombly case, which was saying that their claim does not show that the policy was racially motivated. Just because it was carried out in a racially motivated way does not mean the people at the top said, you know what, we're going to round up all Middle Eastern people. That just means that the people at the top said we need to round up any suspected people, and then the people at the bottom maybe did something racially motivated. Again, an interesting thing, but all that racial stuff set aside, it was an interesting reaffirming of this new interpretation of Rule 8. Which was moving away from a short, plain statement into a showing kind of a thing. So essentially it raised the bar for the amount of ways that you could bring about a claim. And so you really need to do your prep work in saying, here's the claim, here's the facts that we have, here's the evidence that we have already, and this is before discovery. So it made things a little bit more complicated for people trying to bring a case. And then the other thing that we talked about a lot is we talked about jurisdiction. And so we talked about, when it comes to jurisdiction, there's either the federal courts or the state courts where you can go and you can bring if you hear that siren, sorry, once again, city life, but where you can go and you can bring about a claim in state court or in federal court. And usually, like for federal court, for example, the way that you would find jurisdiction would be, are you asking a federal question, or do you have complete diversity within the case? And so diversity is, two different citizens of two different states. When it comes to corporations, since they're people and they can be citizens of a state, that's something that we'll actually talk about in a little bit. But the other one is asking a federal question, and a federal question means like, an agency policy, the Constitution, a federal statute. Those are all super easy ways to say we challenge this federal statute to be unconstitutional, or this person violated this federal statute, or something like that. But the citizenship thing, dealing with corporations, is a really, really interesting examination within the legal sphere. And there are 3 cases that really, really go and inform this in terms of determining whether or not a company is the citizen of a certain state. So the initial rule was essentially like either someone being physically present within the state or a company being incorporated within that state. And the physical presence in the state was something that was pretty freaking hilarious if you do a little bit of research into it. One of the big cases that finally changed all this was a case called International Shoe Co. And so International Shoe was this company that sold shoes, just sold shoes, didn't have stores, didn't have anything like that, and it was in Washington state. And so Washington had set up this new tax, and they were trying to collect back taxes on this company. So Washington state went and sued International Shoe, and they brought them into a Washington state court. And International Shoe said, whoa, man, you can collect taxes on us all you want. You can't sue us in Washington because we're not subject to your jurisdiction. If you want to come sue us, then you have to come to, I think it was Michigan or Minnesota, or it was something like that. St. Louis. so wherever St. Louis is. But you have to come and sue us there or where we're incorporated, which I think was also in Delaware. Like in St. Louis was their headquarters, and they were incorporated in Delaware. And so the court said, no, you are subject to the laws of Washington state because, and this is the main money phrase, is you have a continuous and systematic presence within Washington. So that means that for like 3 years they had a continuous number of salesmen that were operating within Washington state. And then also they were continuously like renting out spaces to be their showrooms. They weren't like selling them there. They were collecting order forms and then mailing them back to Washington. And so, because you have a continuous and systematic presence, you are therefore like subject to the jurisdiction of Washington state, which is super interesting. And then the next thing that sets kind of the minimum bar. The next case was a case called Worldwide Volkswagen. And so Worldwide Volkswagen was also a super interesting case. So there's this guy, okay? This guy he bought a car. He bought a car in New York. He was on his way to Arizona, okay? So as he was driving to Arizona, then he got into a car crash in Oklahoma. Now, as far as the court can figure out, in this guy, so it was a products liability case. He got hit. He was in a rear end, and then his wife, and his child were burnt pretty badly because of the location of the gas tank. And so they brought a products liability suit against Worldwide Volkswagen and several of their other kind of companies, the manufacturer, the distributor, the worldwide headquarters, all those kinds of things. And they sued them in Oklahoma court. Okay. So, and the reason they sued them in Oklahoma court was because they had lots of juries that were super friendly to products liabilities and plaintiffs and, anti-corporate kind of a thing. And so, what the court said is that they did their exploration, and they found that there was no businesses, there was no retailers, there was no dealerships, there was no direct selling of the cars to that market. And as far as they were concerned, this might have been the first Volkswagen car to be in that state at the time. This was the only one. And so the court went and examined that and said, just because you're introducing something into the stream of commerce based on our more modernized and automated society where you're just mass producing things that go and can essentially end up anywhere in the world, does that mean that you're subject to the jurisdiction of that state? And the court said, no, you're not. That's not enough. If international shoe is the like base standard, then Worldwide Volkswagen is a demonstration of what is not enough. So that was a super interesting case. And the last one is a case called Burger King. And that's essentially Burger King versus, I think his name starts with an R, but I can't really remember what it is. But essentially what he was saying was there was this guy, and this one was in Michigan or Minnesota, but they went and they said, hey, it's a great idea. Let's go and get a Burger King franchise. And so they reached out to Burger King, and Burger King said, all right, sounds good. We're a Florida company, so come on down and get some training and sign the contracts and all that stuff, and then you'll be good. And so the guy said, all right, fantastic. They traveled down to Florida. They signed the contract. They did the training. They went back up to Michigan or Minnesota, and they started ordering their equipment. They found a proper place, and they opened up a franchise, and everything was going great. Then something happened where they were unable to get their rent paid on time or something like that, and Burger King sued them and hailed them into Florida court. And so the guys said, whoa, why are we in Florida court? Our franchise is in Michigan or Minnesota. We're here. We're citizens here. We were paying rent, or no, they weren't paying rent. But all these different things. And so the court basically said you should have known better. There's a stipulation within the contract that said this is subject to Florida law. And there's also you were buying equipment from them. You went and got a contract and you signed it there. You went and you did a training in Florida, all this stuff. And so essentially what it was is, yeah, you should have known better. Yeah, what the hell? So that's also something that really, really informs where you're subject to the jurisdiction of those state laws. When it comes to individuals, a lot of times it's like, did you break the law in that state? If you did, too bad. But there's lots and lots of different things. But those are just two subjects. Those are just two things. What exactly a claim is, what you can do. and whether or not you're subject to jurisdiction. But there was a ton of other stuff that we learned, but that's just a little taste of something that we spent a good, 2 or 3 weeks on. Okay, I think next week we're going to talk about contracts. Yeah? All right. And got finals coming up, and have a little bit of fog this morning, so it's cleaning out the air a little bit, which is nice. But, hope everyone had a great weekend, and I'll see you soon. All right, see you guys.
So you can see